You're listening to the Immigration Lawyers Toolbox Podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, Immigration Lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to, I'm not sure what number episode is this because I'm jumping in doing a special edition. So we'll just get into it. Before I start, I want to say it's not intended as individual legal guidance. Please consult with the attorney. The information here is not intended as individual legal guidance, not for that. So for colleagues listening to this, I want to get this one out because I read through the Federal Registrar excruciating details of a 42 or 46 page breakdown of the F-1, J-1, and I visa updates. I'm not going to go through the I version of it because it's just not, pertains to what I typically handle and the more important stuff that's going to affect a lot of people. I can't say it's more important because it's going to affect international press and freedom of press. So it has its own political interests that are at odds there. But for our day-to-day operations, the F and J become really important. And so I want to go over the details of this. I'm going to share my screen while I'm going through it. Notes I've taken to just bring up because there is a comment period that's going to end in less than a month. And I'll have a link to where you can go there to leave it with specific pages and talking points we're going to go through of what's problematic with this and why it's just going to cost taxpayers a lot of money, wasted money. The university is going to get hit by this, and people are unnecessarily going to get hit by this. It's the conclusion of it all is this is just a tactic to get people stuck with a 3 or 10-year bar and to kick them out of the U.S. and ban them much easier for accidental overstays or accidental misrepresentation claims. But it's just some of the stuff was here was kind of ludicrous. So I was like, I got to talk about this. Immigration lawyers find this interesting. And again, you can make the comment period to hopefully, some wise ears hear about it. At least it goes on some record somewhere that people made noise about this. So again, this is about the F, J, and I visa, I being foreign information, representatives, reporters, and the like, news agencies, F, student visas, and J's, non-immigrant visitors. So let's go to page 404. Okay, it's like 42,070. I'll just hit the last two digits. So on page 71, one of the first parts that comes up, which was kind of hilarious, it goes into the history of how the DS came about. So this is going to help a lot of people who are new to immigration law, don't do student visas, a lot of that history of how it works, and not history, even the law, how it works with duration of status and grace periods and all this kind of stuff. So it'll be interesting. Last action rule comes into place here, EADs, extensions. So it's good to know this kind of stuff. I'm not going to go through all of it, but if you want to learn immigration law really well, especially on these kind of topics, it's really good to read through this stuff. It's a great education. So the DS system came up in 1978 for F visas, 1985 for J visas. And the goal is to make it easier for people to be able to just come and go and not have to do extension of status. Because imagine it's a hassle to have to do an I-539 extension of status, filing fees, more government delays to be able to keep going to school here. Especially as people go to college here, probably go to either grad school too, or they do OPT afterwards and all this kind of stuff. So having to file extension of status becomes a big hassle. And they say they cite that in 2023 alone, there were 1.6 million admissions in F status, a dramatic rise from when legacy INS naturalization first shifted in 1971. So this is kind of misleading because in 1980 there wasn't as much air travel. This 1.6 million number, most likely it's from this what is it, footnotes right here. I looked up this naturalization yearbook, not naturalization yearbook, I'm sorry, the legal immigration adjustment of status report, and I couldn't get a breakdown of what this number was, but most likely, I'm 9 out of 10 sure, that 1.6 is the number of admissions in F status. So if you have a Mexican student who came to San Diego to study and then on the weekends goes back home, each admission is just this one person doing the same trip. So when you say 1.6 million admissions, that could be a smaller number. It would be a smaller number. People who travel for summer, for winter, they might go on vacation to Canada. So that's a very misleading number to put up there. And so that was just kind of a joke that they were going to cite those kind of numbers. And it shows kind of a misleading thing they do. They said in 2023, there were over 500 admissions in J status and over 250%, up from over 250%. For J's since 1985. And it's not really a comparison with today's travel and internationalism that exist from that time. And they're saying this poses a challenge to the Department of State's ability to monitor and oversee these non-immigrants while they're in the United States, which is not really true. And this is going to be a continuous theme is They're searching for a solution here for a problem that has already been solved. And the problem is called SEVIS, SEVIS. Schools list if a student's not maintaining status, drops under, gets bad grades, they get reported into ICE's system. Now, I'll give it to them that they didn't have enough ICE officers, and this has been abundantly clear, reported on many times by the government for a decade plus, that they don't have enough ICE officers relative to the number of students because the student numbers have grown. That's factual. And so they just don't do anything. So they get reports of all the problems that are happening, that not all of it, the problems that do happen with the students, but they don't do anything about it. But they've already solved that solution with the big, beautiful bill and hired all these ICE officers. All they got to do is get the CVIS report, send a letter to students, and send an NTA if it's the case, if it's a problem. They don't have to create this whole bureaucratic system, which we'll see is going to cost hundreds of millions of dollars when they can solve it with the existing systems that they have just by sending letters to people to do an NTA, and that takes them out of a duration of status because they got to notice. I think it has to be a finding, so maybe by a judge or just some USCIS notice that says they're out of status or RFE on it. So there's much simpler ways to deal with this. It doesn't need to create this extra bureaucracy that goes with it. Another thing that they say here, again, goes to like kind of how ridiculous this is. They cite that in footnote 16, DHS has identified 2,100 aliens who first entered the F-1 students between 2000 and 2010 and remain active status as of 2025. So the biggest problem they have that they're trying to solve is 2,100 people that have been staying the F-1 student status. They've identified these people. They know who they are. If you charge $10,000 a person in employee fees to go and handle this, which is going to be much less than that, but that's going to be only like, I can't even do the math, but it's like $2 million, $20 million, something like that. Not the $300,000 to $400,000 they're quoting to kind of solve this problem, that they're the new solution that they're putting. So it shows again that it's a taxpayer issue. They're going to spend a lot of money and cause a lot of havoc in upper education for creating this. And so they go into here for F&J visa holders. The Immigration Nationality Act specifically states that aliens must have a residence in a foreign country which they have no intention of abandoning to enter U.S. Yet DHS has many examples of students and exchange visitors staying here for decades. That's where the reference is 2100 there. This has always been a problem if you're doing an extension of status in the U.S. or change of status to a B2 or F1 or all this kind of stuff about the home residence requirement. It's very hard to do that. If you've been staying here 4 years of college, you're not going to keep a home back home. But that's how it's been. Now, I want to reference that this is page 71. If you jump ahead to page 87, let me try to find that, 77, 87. They reference these numbers again, and you be the judge. I might be reading this wrong, to be honest, but here they say, in 2024, DHS identified nearly 77,000 F1 students who haven't spent more than 10 years in the U.S. since SEVIS was implemented. So again, they're identifying that they have the solution, SEVIS, that identifies these specific students they have a problem with. They admit that they have the solution right there already for the problem they're trying to solve for. But here they're saying 77,000 students. In that first footnote, they're saying 2,100. Is there some sort of miscalculation? Why would they calculate something at 2,100 there, 77,000 here? And again, if they identify this one. Now, then the footnote, they say it's based on a student exchange visitor program analysis of data in the student exchange visitor information system and valid as of March 17, 2025. I don't know if we have access to that system. Probably needs an audit, a FOIA, or something like that to see how they came out with that number, who these are. We had the situation a couple of months back where they just canceled a bunch of student visas, H-1B, all this kind of stuff for people who may have had a run at the police, even, benign stuff, mistakes and stuff. All these visas were voided, and there's lawsuits happening on that. They have to pull that back. And so I'm guessing this analysis is very similar to that one, especially internally when this two footnotes have such different numbers. That's a huge inconsistency. Let's say 2,100, they said maybe 5,000. Okay, the numbers are different, or they're just only calculating for the first 2000 to 2010, doesn't include the next decade. But a jump from 2,100 to 77,000, that's questionable as how the statistics are being used right there. So let's go to page 72 now. I hope this is interesting enough to keep you engaged in all this. This really goes to like my hypothesis that this situation exists. The 9/11 report reiterated it needed to have a system to track foreign students and place tight controls on student visas. We have the schools, DOS, DSOs, the designated school officials. We have SEVIS. These people or these students, they're tracked. They've always been tracked. So I'm not sure what their worry is per se about this kind of stuff. It goes into the I visas here about them exploiting the system, which I'm not going to get into here. But they also talk about complying with conditions of their classification. And that's what the big deal they're making. We need to do, and this is the big change, is a person who's here on a student visa needs to do extension of status after 4 years, essentially, if you're going to college. So they have a time to double check you're doing things right. But that's what CVIS is for. So what's going to happen now is someone who graduates from a 4-year school and then wants to do 1 year of OPT has to not only file the EAD timely, which we'll mess up on all the time, file the wrong I-20, file it before the 30 days are up, put the wrong code number in, all this kind of mess ups. But they also need to file an extension of status from I-539, more filing fees, and more errors that could pop up, and delays in to be able to get the OPT work authorization. All these kind of problems are going to emerge from here. But they're saying we need to check them up when we file the I-539, so we check on that, which is, you could already check on that. No one's ever stopped you from doing that. That's a term of the visa that could be done. So this is a really misleading aspect there. Frankly, what's going to happen to a lot of people is they may mistakenly work with authorization. They do CPT, and the I-20 says it ends August 31st. They're still working September 1st, 1 day off. That's unauthorized employment. Typically, it's not a problem if they're going to leave or something like that. But now, if they do an I-539 to go to OPT, in that I-539, there's a question: have you worked with authorization? They say no, and then that 1 day gets caught in there in some sort of system, and they're stuck with misrep for a simple mistake that happens pretty frequently. Here on the bottom of page 72, there's another part that says specifying the effect of departure on F and J visas application. This is an interesting one that we're going to get into more. Is that it almost codifies the fact that POSA period of authorized stay authorized by Attorney General of the United States, that may be considered authorized period of stay that I did another special episode where I interviewed Samir Kedeker about this, where if you have an extension of status, change of status, even just in case pending, once your underlying status ends, you're in an authorized period of stay, so you don't accumulate unlawful presence stays. That's a whole technical conversation there. On our free community page for immigration lawyers or just lawyers, we have a breakdown of a 3 to 10 year bar. All that stuff, you go watch their video. You go email me if you want to join the community with your bar info at immigrationlawyerstoolbox.com. But what we see is that they're specifically saying that once you file the extension of status, even though the underlying F-1's done, by that point your I-94 is expired with this new system, you're authorized to stay here. They're saying it specifically. So if they're saying it in this kind of context, this is one of those things that can be used in others and say, why are you NTAing me? You're explicitly now saying this is a status and you shouldn't be doing that. It says allowing F non-immigrants to timely file EOS applications it specifies Fs, but to remain pending after their admission period has expired to receive automatic extension of the current authorization for on-campus office. This is about work authorization, but it goes in more details. I'll get to it in the next sections that come into it. But that's the interesting thing that came up there. This column right here has the main talking points of what the changes are going to be, so I'll go through that really quickly. They want to have F and J's not to exceed 4 years. If you're coming to community college, it's probably going to be 2 years, or language school is 24 months. They're saying a student, this is really annoying. If they're going to change their program in the grad school, they can't. Does that mean that they can go home, get a new program, get a new I-20, come back, or they just can't change this program while they're here? That's going to be a weird thing. And also, if you come to one school with your I-20, the first year you can't change unless there's emergency situations that have to happen. I actually had a consultation with a person who came I-20 before class started. They immediately changed schools, and the school wasn't happy with it. But I was like, if I just read this, I'm like, who does that? But then right before I read this, had a consultation, had the same scenario. So they require, who knows if this is all going to go through, but this is what they want. Prohibiting F-1 students at graduate education level from changing programs at any point during a program of study. So I guess they'd have to kind of drop out, get a new I-20, and come back in. That's going to be extremely harsh. In grad school, if you're studying law, you're not going to change your program per se, but if some other program, science and stuff, engineers, they probably do that all the time. Requiring any non-immigrant who completed a program at one education level to only be allowed to begin another program at a higher education level while in F-1 status, prohibiting a change of the same or lower education. This is big, decreasing from 60 days to 30 days, the grace period. And that's going to be a shame. That's going to be very difficult because you graduate, you have a house, a car potentially, you have friends, you want to save out, you want to see America, you got to sell stuff. That's a big rush. A 60-day grace period, it makes sense. That's a really harsh thing for them to change. And then 24 months for language school, that's okay, I guess. Who knows? And then providing that delay in completing one's program by the program end date specified in the Form I-20, which includes, but is not limited to, delays caused by academic probation or suspension or students repeated. Essentially, they're saying unacceptable. They won't give the extension if you're not living up to what you need to as a student and finishing up your stuff. So they're going to get more harsher on that. So let's move on to page 474 is nothing. So there's a lot of reading of the gaps here, just repetitive language or annoying stuff. This is really annoying. Really quick, go to 4076. And it talks about, this kind of goes to the fact that the whole unauthorized employment misrep, extension of status without reference, that's going to be something people are going to get hit because they may, on the I-539 extension of status, there's going to be mistakes that will happen and they're going to cause them to look like misrep on that form. Okay, so here are the problems they've had. Risks with the F-1 classification. This is why they're doing this. Since 2008, multiple school owners and others have been criminally prosecuted for pay-to-stay fraud in which school officials, in return for cash payments, falsely report that F-1 students who do not attend school are maintaining their student status. How is this extension of status requirement that they're putting going to solve this issue? They also go into next page 470. These are things you complain about. It's like, how exactly does what your system you're doing that's hundreds of $millions going to solve this issue? Here on page 4078, it talks about this too. Example, students claiming to maintain status when they're not, such as failing to attend class or working without appropriate authorization, or school owners not requiring enrolled students to attend class or creating fraudulent documents. That's bad, but how is creating a 4-year period for it's going to solve that situation? That part I didn't understand. I might be dense, I might not be able to understand it, but how does filing I-539 solve that other than creating a way to just cut people off on I-94 and get a 3 or 10 year bar on them if they're overstay? That's the golden goose, because the last time they tried to do this, last administration or lawsuit had to stop it. So I think they have to tag on these kind of explanations to come up with something to make it palatable for future lawsuits. But I think you clearly see over this one. Now, one educational part is they're going to have a situation where people are going to travel when they have their extension of status pending. And typically in immigration law, if you have an I-539 extension of status pending, if you travel, it doesn't automatically abandon the application. It's a very interesting thing. If you're doing change of status, it will. The first change of status, just one change of status, but extension of status, and you travel and your visa is still valid, that doesn't happen. This usually comes about because automatic revalidation, potentially if you're traveling, like Canada or Mexico. But the last action rule comes into place. They bring it here. It doesn't come into place here. So they say, for example, if you leave and have an I-20 and you come back in, CBP issues a new I-94. And that might give you more time based on a new I-20 you got. So then that way you don't need to do I-539. And so if you have an I-539 pending and you leave and you come back and CBP issues a new one, USCIS will consider the US abandoned and you have the I-94 on the other one. Now, typically, if they don't abandon it, if they don't realize that, which are not going to for sure, they're going to approve a new one, and that's going to be a last actual situation where the second one applies, or potentially they consider that one abandoned or they deny it for some reason. Then you're stuck getting the previous I-94 you had denied potentially or misread like that. So it creates a lot of confusion in the system. And the last action rule used to be like whatever last application is approved, you have to go by that. So you have to kind of like affirmatively try to withdraw the potentially I-539 so it doesn't get caught in this loop of this black hole of a mess of stuff happening. And that last action rule is a complete mess of a rule to understand. Automatic validation from Canada and stuff, that's going to be a problem. And speaking of automatic revalidation, they're updating the language of it. And you see this on page 83 on section B, that they're going to change it. DHS proposes to change the admission language in the provision related to extension of the visa validity in limited situations from shall to may to clarify that CBP always maintains discretion to determine whether an alien is admissible in the appropriate period of admission. So I probably should this before, but look at the statute, wherever that power comes from, to see what they say over there, if this matches what the statute is. But these are the kind of changes they're making there. Here it talks kind of this last action stuff. While USCIS generally does not consider an application for extension of status abandoned when the non-immigrant leaves the United States, so that's good to have there, just understanding for those who are unfamiliar with the extension of status. Comes up a lot of times when you have like an L1 or like an H1B extension pending, they travel, they can still come back in. They can still keep that extension going. It happens like when you have an L, that's not going to expire for 5 or 6 months. And while you're still in L1 status and you have an extension pending, you travel and come back. That doesn't necessarily cause that extension be withdrawn. So don't tell your clients to stay here. I mean, now with Trump, who knows, stay here, be safe, but don't stop you from traveling per se, because the law doesn't say that. It says DHS recognizes the potential for a conflict if a non-immigrant receives authorization from both CBP and USCIS for what amounts to the same request. So they recognize this kind of issue that pops. So the last action will come up there. And then it goes into a lot of details about how it's going to work with this whole situation, every case pending or not, different factual scenarios, and the fact that with OPT, you're going to have to submit an extension of status in these cases. We're moving to page 84. Here it says, should an U.S. application be deemed abandoned, USCIS would continue processing any application for employment authorization. So if you have this scenario where you return and you got the I-94 anyway from CBP, so the I-539 you had pending that's abandoned, your work authorization would continue. Now they say that, but we all know how this bureaucracy works. So that creates another issue that's going to happen. If they mistakenly deny the EAD because the I-539 was abandoned or denied, or it just becomes a mess. You know that's going to happen. That's something it's going to create a lot of immigration legal work to try to fix this up. And students are at this point, a lot of times most of the times they don't hire lawyers, but at this point they'll be wise to do that for those who do end up coming to the United States. There's one factual thing this morning I read, or yesterday morning I read, LA Times, it was this morning, that said that because of the financial difficulties schools are experiencing with lower admission and costs going and everything like that, for a four-year undergraduates, there's less and less of those, I mean, we went to college, I forget what they call it, the basic courses you got to take to complete your credits. They don't have enough of those. So sometimes students will come and they won't get those basic classes they need, like Biology 101, until their sophomore or junior year. And so that automatically forces them to get more and more a rising amount of people who are not able to finish an undergraduate degree in 4 years. It's going to be 5 or 6 years. So you see, like, and then the government might claim, oh, you're not taking care of your classes, you're taking too long to take those basic classes, you're forcing yourself up. So it creates a lot of havoc with what they're doing, essentially destroying higher education in the United States. It's literally not just this, but the F-1 stuff they're doing it's crazy. They're going to destroy this like cash cow that's exists in the United States. I mean, I'm not the biggest pro higher education fan. I've had higher education. It has a lot of problems, the system we have. So some of it is probably good to fix it, but the way they're fixing it is not the way to go. But I'm preaching to acquire pride for people listening to this. F and J, this goes back into if you're admitted to DS or in the U.S. Without filing U.S. requests at the permanent end date, blah. I don't want to go too much into the details. There's a lot of like nuanced stuff, and also people already on DS might not be affected by this. And then it goes into departs. A lot of it is repeat. It's like this repeat of these facts about period of authorized stay I would mention. And that's the big picture. So, I mean, this is 46 pages. There's a lot of information there. Half of it is repeat. But I wanted to get this out there so you're familiar with what pages there are and file comments and stuff to let them know about what you think the issues are. Read it for yourself, confirm if I'm correct, and put your own notes on there. To put in the record, this is really a waste of taxpayer money to do something like this, and it's going to destroy a lot of things. Our influence in the world, if you think that foreign people are coming here to like do nasty stuff here, you have systems designed to stop that. We have CBP, we have DOS, we have CBIS, ICE comes, schools are watching. There's a myriad of systems to protect from this. But the biggest thing that the student situation does, they come here, learn from our values, go back to our home country and look around and say, dang, America's so much better. We got to make a change here. I don't like it as here. So it's one of the biggest mechanisms, soft power that we have that affects the world. And unfortunately, since I've grown up, since in the last 25 years, since I've been able to vote, which I try not to do as much as possible, but since I've been able to vote, it's just hard power. Everything is hard power. It's like you have a hammer and everything's a nail. It's like you got to be wise. Wisdom is the reason we have wisdom. But that's what we're dealing with right now. And I want to share this with you. It's interesting stuff. You're in immigration, you're into this. But that's what the Immigration Lawyers Toolbox is all about. Help you bring attention to matters, help your education, legal knowledge, help promote immigration lawyers. So check out our magazine. Issue number 10 is out. We have 7 articles in there that are very helpful to increase your practice, finances, business, and learn about the law in humanitarian cases and business cases and all the like. So check it out. Go to immigrationlawyerstoolbox.com. And that's click on the magazine tab for that. And click on the community tab and join our private community page. I hope that helped. Until next one, have a good one. If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.